I was jealous as I watched people kind of popping up on screen. I saw Kelly with her dog, and I saw others, kind of enjoying the indoors, and it's a good day to do that. If I was at home, I would showcase Digby, the golden retriever, and Spencer, the Chihuahua mix of some sort, and they would be glad to say hello to everyone. But I am here in the crow's nest here at Crowell & Dunlevy in one of our conference rooms. And I wish I could see all of you guys in person, but it sure is nice to be able to be here today. Everybody's getting to put in their name so they get credit. I don't need any credit, but I have the boring name of Crowell & Dunlevy, Oklahoma City. So if I get a chance later, I might go with Matthew McConaughey or Ryan Gosling or something like that, something that might, inspire a little bit more viewership. But I'm lucky just to be able to turn on a computer, so I probably won't get that done before my time with you is finished. Did want to just make one brief plug, and it's kind of a passion project of mine. I've been asking the firm to help me put together a podcast for a long time. I have a face made for radio, and so I insisted that they give me this opportunity, and that has finally happened. The name of the podcast is Briefly Legal. It is brought to you by the law firm of Crowell & Dunlevy. We drop new episodes every 2 weeks. You see that? I said we drop episodes. That's kind of the parlance. Those of us in the biz, we know all these things, but you can consume it wherever you go to watch podcasts or listen to podcasts, Spotify, Apple. For those of you who receive the Crowell & Dunlevy advisories and newsletters, you can ask to opt in and get updates with links when the podcast drops. But anyway, it's a ton of fun. Really enjoy it. I'm going to look for opportunities in the future for members of the HR community to join me. So if you like it and you dig it and you want to be a part of it, drop me a line. Sure would love to talk to you about it. But enough about that. Let's talk about what we have gathered here virtually for today, and that is a look into the looking glass. The Biden-Harris administration is here, and that means that we should see, most likely, some seismic changes when it comes to labor and employment laws that are going to affect the workplace. This is one of my favorite topics to do. About every 4 years, I get asked to do this, and the reason I love them so much is technically I can't be wrong about anything I say today. Because I'm going to give you my best guess on things that have happened, are going to happen, and are likely to happen, but all of this is subject to change, and the winds of Congress and how they choose to go, and what the Biden administration chooses to push forward in their agenda. But I've done my level best to put together some materials that I hope will help guide us through this. And so, through the magic of technology here, I am going to share my screen with everyone, and hopefully you will be able to follow along with my PowerPoint. And I do apologize, you will lose the ability to see me face to face, and so that may help. They may help with digestion of breakfast, but you will now have the opportunity to see my PowerPoint. So let's do that now. Hold on just a moment. All right. I need to get this out of the way. How do I get the? Okay. Give me just a second here. I've got this giant bar in the way of what I want to do, which is start the slideshow. Well, let's just go from the beginning and see if that does it. Look at that. Who says that I'm a walking lawyer joke when it comes to technology? Not this guy. All right. So let's dive on in. We've got your title there: New Year, New Administration, New Employment Laws. let's matriculate, if we will, to a glimpse into our future. Oh, and here is our obligatory waiver that the good folks in ethics asked me to put up. Always to remind you that, well, first and foremost, that I'm the Labor and Employment Practice Group co-chair, which I'm very proud of, along with my law partner, Randall Snapp in Tulsa, but also that everything I'm about to say should never be considered a substitute for specific legal advice. I have complained that this makes it sound as though what I'm about to talk about is not legal advice at all, which seems silly to me, but there it is. And please always consult with the attorney of your choice when you have specific questions. All right, so here's what's on tap, guys. We're gonna just briefly touch on a couple of things that happened in 2020 that I think will help us understand what is coming our way in 2021. That'll be a nice segue into what to expect under the Biden administration. And we'll take a look at some regulatory administrative changes, but also some very specific legislation that is already in the works that I think will most likely pass through the Senate and the House and become law in the not so distant future. I don't know if any of you have, I don't want to, spoiler alert, they do have a few other things going on starting actually today and probably happening right now. There is a second impeachment trial that's consuming a little bit of time, but I do think many of these things that we're going to discuss today, we're going to see happen within the first 100 days of the Biden administration. So let's jump in though first into important developments in the year 2020 and what it means for the year to come here in 2021. All right, so I think really the most significant development in terms of labor and employment law and long-lasting impact on the landscape of employment law was the introduction of the Families First Coronavirus Relief Act, because you never can get enough alliteration in your life. The FFCRA is the revision to the Family and Medical Leave Act. It happened in a hurry. You will remember that in the early days of the pandemic, there was immediate concern as we moved into a quarantine state and as we had lots of people missing time and being away from work. There was a very hurried effort by Congress to address that through the FFCRA. Remember that the FFCRA essentially allows for paid emergency sick leave, and that's up to 80 hours for certain qualifying conditions, as well as extended sick leave, which is essentially a paid form of FMLA leave using the same structure of the FMLA's 12-week leave, although there's a payment portion that's never been there before at about 2/3 pay. Now it applied to a large swath of employers across the country. There is a small business exception for less than 50 employees. It took into the fall before the Department of Labor explained that didn't exempt you completely, which put a few small employers in a terrible mess. And then also it did not apply to employers with more than 500 employees. Now, many of you know that expired as of December 31st, 2021. However, buried deep within the 5,793 pages of the Corona virus relief and stimulus package passed by Congress in December was a provision that said the FFCRA, although it expired on its own terms as of December 31st, is still around. For those of you who want to take advantage of the tax credits that get applied when you provide that relief to your employees, you can do so through March of this year. It actually reads as though you can kind of pick and choose when and how you want to do that, but best practices, as I know all of you follow, dictate that if you're going to do it, you should do it uniformly and consistently across the board. And if you decide not to go that direction, it'd be a good idea to update your policies or send out notice to your employees and remind them that that benefit has ended. But why is the FFCRA such a talisman for what to expect in 2021? Well, number one, I think it showcased how Congress is able to do in a very short amount of time something that really both sides had talked about. Even the U.S. Chamber of Commerce had given in somewhat on the idea that there would be some sort of paid leave component of the FMLA, but there really was no movement, no solid movement towards making that happen. And then the pandemic changed everything. And almost overnight, we were granted a paid leave benefit that heretofore was not something that I thought was ever going to have enough members of Congress coalesce behind. So FFCRA is important not only because it was one of the defining pieces of federal legislation that employers had to deal with in 2020, but also because I think it tells us that big things are ahead in 2021 and beyond, and this is a roadmap for how they may get there. It's amazing that the pandemic crowded out what really was the biggest event on the labor and employment calendar in 2020, which is the United States Supreme Court deciding once and for all with a conservatively packed court. It is more so packed that way after the death of Ruth Bader Ginsburg last year. Nonetheless, it happened on a conservative court watch that Title VII was officially expanded to be interpreted to include sexual orientation and gender identity as protected classes under Title VII, meaning that if you were so busy in 2020 dealing with furloughs and reductions in force and reduced time and hours and pandemic planning, that you kind of put this on the back burner, 2021 is a good time to remind yourself that we need to update our employment policies to include sexual orientation, gender identity in those same categories of protected classes that we have otherwise in our employee handbooks, and also to remember those issues as you go through the investigative process and receive complaints of a hostile work environment or of discrimination or differential treatment based on sexual orientation or gender identity. The answer used to be it's not a protected category, and absent maybe some stereotyping issues that would come into play, most employment lawyers would tell you how you handle that is really your choice in terms of what you want to do within the workforce. And that's no longer the case, as we learned from Bostic and the US Supreme Court through a trilogy of cases actually last year. Other big changes that happened last year that are important for us to understand as we move into 2021, the United States Department of Labor took a very hard look at the independent contractor rule, its interpretation, and they went through a rulemaking process. They took a huge amount of public comment and came up with a new shiny rule with interpretations that were immediately suspended and likely to be toppled by the new administration. But it does not mean that it's not important, because it at least sets the standard going into 2021 for what was a much looser standard for getting to the point of proving an independent contractor relationship. And I'll talk in a few moments about why I think that will change and what that means for you and your workplace going forward. Wage and hour issues. The minimum wage was tinkered with by Congress, the thought of making changes, but that fizzled out. And also there's this continuing, you'll remember, since 2016, in the waning days of the Obama administration, when there were wholesale changes to the salary test, the duties test, and basically how we decide who's exempt and non-exempt. We have been kind of locked in a battle about when we will make changes to the Fair Labor Standards Act. Those changes made by the Obama administration were quickly undone by the Trump administration and Congress through the Congressional Reconciliation Act. You are going to see similar actions take place in these first 100 days of the Biden and Harris administration. And I'm going to talk to you soon about what that means in terms of what you need to be thinking about for preparing for what I think will be a workplace where we are going to go back much closer to what the Obama administration was proposing in late 2016. And then finally, I think the thing that happened in 2020 that was eye-catching and is only going to become more and more important, and really in some ways a steamroller of importance for employers, and that is the enforcement actions of the Occupational Safety and Health Administration, or OSHA. OSHA was a little bit slow out of the gate with the pandemic, but they picked up steam, and they are certainly getting more and more power and influence and in the new administration. And I will detail for you what I think that means in terms of 2021 and beyond. All right, so that is what happened in 2020 that caught my eye and set the stage for what happens from January 20th of 2021 forward. So we're just in the first 30 days, first month of the administration, but it is surprising how many changes have been made that are already impacting the workplace, and I only expect that to exponentially grow. Okay, so what are the numbers? You know, you will hear quite a few pundits tell you, well, the Democrats have a supermajority. So that means that whatever the agenda the administration wants to push is going to happen. I urge caution for any of you who consume politics and believe that all the talking heads are right on that. That has not always been the case when it comes to important change in employment law. This is the first supermajority Democrats have had since the very first 2 years of the Obama administration. And you will remember that outside of healthcare, there weren't seismic changes that really were able to be implemented, at least as it relates to the workforce. You're talking about a 50-50 tie in the Senate with Vice President Harris serving as your tiebreaker, and a 10-vote advantage in the House of Representatives favoring Democrats, still one sort of in play for purposes of voting. So it is not an overwhelming majority, and so I still think that we are likely to see a lot of changes that are going to take place, perhaps through executive orders or other actions. I think the most important thing that you're going to see is who's put in charge. The Secretary of Labor is the mayor out of Boston, Marty Walsh. He was recently confirmed. One thing, at least, that I think we will see is that with the Senate being held by the Democrats, there at least won't be a long holdup on a lot of these positions, but we're looking to see who the commissioners will be, and the National Labor Relations Board commissioners. The Republican NLRB members will still hold their majority by most accounts until at least August of this year. And many of you are saying, well, I'm not a unionized setting, so I'm not going to give that much attention. Remember, though, that the NLRB still controls and interprets rules that relate to a lot of how we conduct our workplace, even in a non-unionized setting. And remember that the Obama administration had an NLRB board that came out with some very aggressive opinion letters on things like restrictions on social media and other sort of concerted activities that could be viewed as moving towards a unionization effort, that there was really some tough restrictions put in place for employers, including what you could even have in your handbook. There was even restrictions for a while put on whether or not you could bar someone from coming in to be a witness during an investigation, which had never been seen before. So keep an eye on what happens after August when the NLRB's composition changes. I think you're going to see some major changes and perhaps some callbacks to some of those tough regulations and interpretations that were in place with the NLRB. I think we're also going to see enhanced enforcement, a higher volume of so-called A charges with the Equal Employment Opportunity Commission, more on-site investigations, increased budget, more investigators, and more fun when it comes to DOL and EEOC investigations. And then OSHA enforcement is really on the rise. And so I can't stress this one enough, particularly for those of you in sectors where you have workers that are either engaged in healthcare or interact and interface with the public on a very routine basis. OSHA is being empowered to take a harder look at what you are doing, whether you're updating your OSHA logs, your OSHA 300 logs, when you have sickness that can be attributed to work through COVID virus specifically. I've had COVID deaths that have led to wide-scale OSHA investigations. I've seen a lot of fines that are being put in place for not following proper procedures when it comes to PPE. It's not enough just to provide it. You need to have training for how to use the PPE. You've got to have up-to-date and PPE that is available, and you really need to train them on how to use it. You need to be looking at seals, making sure that they are in good working shape. They are not giving just a cursory review as they did in the early days of the pandemic, when there was less understanding of what responsibilities the employer should bear. I think 2021 is going to be a watershed year, and if you have not sat down with your in-house counsel or your external counsel, rather than out-house today, we'll go with external counsel, then you should have kind of an OSHA audit in place to help you make certain that you've got the most up-to-date policies and a good plan in place for dealing with OSHA's enforcement being on the upswing. Now, I referenced this in the previous slide, but let's take a deeper dive. I still believe that with the numbers as close as they are, and some overlap on both sides of the aisle on some issues that are important to both or are particularly repulsive to both, that most major legislative changes are unlikely to pass through Congress. I think you're going to see it through executive orders, heavily through enhanced regulations, restored regulations, or simply guidance documents or enforcement policies that put an increased emphasis on certain aspects of rules that are already in place. Every administration does this. You will no doubt remember some of these things, same things happening in the transition from 2016 into the next 4 years. And we are living through another seismic change today. But what I like to remind employers, particularly those who do a very good job through their human resources department of keeping track of these legislative developments, don't just rely on what the new law is. Pay attention to these executive orders and regulations. We're doing a bang-up job here within my firm of tracking them. We have a legal librarian whose job it is to update the chairs of departments anytime there is any legislative change, federal or state level, and we try to push out that information through advisories to clients and friends of the firm who are part of our mailing list. But whatever your resource is, please make certain that you are tracking these changes, because the tricky thing about regulatory change, and even more so with guidance or enforcement policies, is nothing's really changed on the books, but everything has changed when it comes to how the investigators will be empowered to enforce these things, and what their policies are going to be about, what slack they can provide to you or not provide to you during investigations that take place in 2021. All right, so those are kind of some of the sources where I see changes coming. Now let's talk about some of the specific legislation and regulatory changes that I think you should particularly keep an eye on. Okay, first one, will we see renewed coronavirus relief? I think the answer is undoubtedly yes. The Biden administration made it a campaign point. There's obviously a ton of language in the current stimulus package, the over $1 trillion worth of monies that are waiting to be distributed. Like any good bill passed by Congress and penned by a presidential administration, it is filled with items that go far beyond just putting money in the pockets of those who are burdened by this pandemic. It actually also goes into issues that are far-reaching into the workplace. Most scholars and most employment law practitioners that are watching this feel like if there is not an FFCRA 2.0, there will certainly be at least some efforts to take some portion of it and provide that relief to the American workers. I think everyone's really watching with a close eye. The numbers are starting to come down some on a national level. Transmission rates, death rates are always the last indicator, but even those are starting to tick down. So I think there is some hesitation about ramping up these rights if we are moving towards something that approximates herd immunity in the summertime. But I still think that it is something, if nothing else, will be done as a show of appreciation for that part of the voting populace that is looking for that type of relief. So to the extent that you have employees that didn't use up all their FFCRA last year, they may get a brand new allotment, or for those that never used it at all, or used it up altogether, they may have that opportunity in the near future. So be on the lookout for that. I think we'll definitely see an expansion of LGBTQ rights in the wake of the Bostic and Trilogy decisions last year from the U.S. Supreme Court. You're seeing it already in some executive orders at the federal level, granting additional rights based on sexual orientation, particularly gender identity, though, which is turning out to be really one of the points of emphasis with this administration. But if you are not watching this, you need to be. Your employees, I promise you, are. And there is going to be more and more of these claims this year, and your reaction as an employer is going to dictate how that is being perceived within your workplace, and whether or not you're viewed as an employer that's keeping up with the times, or whether you're one that is ripe for a claim being made. And so watch for that through legislative action, executive order, and really enforcement at the EEOC level. Minimum wage and salary base increase. I'm going to talk about this a little bit more specificity soon, but I don't think there's any doubt that this is coming. It's just a matter of what level we're going to see, particularly with minimum wage. President Biden made comments the other day that seemed to indicate he has come to peace with the fact that as part of the stimulus package on coronavirus, his $15 minimum wage is not going to make it through. That doesn't mean it's the end of that struggle, but I don't believe we'll see it in the first 100 days, but keep an eye on it. And then we're going to talk about these in more specificity here in just a second, but independent contractor, joint employer are both already undergoing big changes. And then finally, the FMLA. Remember, Ivanka Trump, President Trump's daughter, was a big proponent of paid FMLA leave, at least under certain conditions. The U.S. Chamber of Commerce had its own ideas about that last year. That's already a sea change. Add to that a Democrat in the White House and a supermajority in Congress. I think this will be the year, if not, then the year after, before midterm elections, that we're going to see at a federal level some component of paid FMLA leave. So get ready for that excitement. I know everybody can't wait for intermittent leave, tracking it not just for their 12 weeks, but also to pay them. All right, so let's talk then about where are we at in terms of some of the bigger changes that I can almost guarantee you are coming. So one of the first ones is going to be what about the FLSA exemptions? You'll see there that I whimsically said that we may begin to party like it's late 2016 again. That's because, as I alluded to earlier, late 2016, we were all scrambling because in the 8th and final year of the Obama administration, there was a move to change the minimum level of wages that a exempt employee had to earn. It went up to $47,000. And also there were changes to the duties test, and the conservative numbers used by most of the prognosticators that you can trust and are not inflating for political reasons said that millions were going to become non-exempt employees under that test. It actually was most of the components of those changes were struck down by courts and or subject to an injunction long enough that once the Trump administration came in, that was quickly undone by the Congressional Reconciliation Act. But this is going to be one of the first things that we see return. Will we go back to the $47,000 threshold again? I don't know. 47,000 doesn't seem as high as it did back in 2016. And maybe that's just because people got used to hearing that number back then. And with the passage of time, there's maybe a little bit more of an appetite for it. Somewhere between our current level of 35,000 and 47,000 is my best guess. I know you're saying to yourself, wow, you're a real genius, Adam. You took what it currently is and took what it used to be and said it's somewhere in between there. But hey, I could have said it goes even higher, but I don't think there's the political will to do that. However, I do think that the solution for that will be a supermajority in Congress on the Democrat side saying, let's put some automatic indexing in there for inflation, meaning that that number, whatever they come up with, may increase periodically, whether that's every 2 years, 4 years, moving forward. And if that happens, that's a little bit harder to undo if there's a change in political affiliations of the White House in 4 years. So you will want to keep a very close eye on this, just as you did when the Obama administration made these changes. You're going to have to make some decisions about whether or not you're going to raise some folks to whatever that new threshold is in order to preserve the salary test for exemption. And then you're going to have to look at what the new duties test is going to be. And the duties test is currently the one that's being pushed by the Biden administration is based on the California rule. This is not the first time or the last time I'm going to mention California when discussing changes that we are going to see. And I get a little shiver that starts at the base of my spine and works its way up when I hear the California rule, because God bless them, I do love California and I love to go to the beach and I love everything really about that state, except the laws that they tend to germinate on the West Coast and then find our way here. The California rule essentially says that it's up to the employer. The burden is on the employer to show that an exempt employee is performing those specified exempt duties for a specific percentage of their working hours. And that percentage, if it's anything like the California model, is extremely high, meaning that if that number raises up, somewhere between that $35,000 to $47,000, and you're required to have a more stringent set of duties that they have to perform, and the number of hours they have to devote to it likewise skyrockets. I think that by the time these changes take place, you will be looking at a big change to what non-exempt and exempt looks like in your workforce. Get ahead of it. When these changes start rolling out, it'll most likely happen through the Department of Labor rulemaking process. There will be enough time where at least we should be able to get word out on what we think it's going to be. And then you need to start sitting down, and I did this in 2016, and you'll need to do it with your employment council in 2021. You're going to need to look at the job duties for your non-exempt employees, look at their salaries, and make some very tough decisions so that you can get out ahead of it before it becomes something that trips you up through a DOL investigation. Okay, another big change that is already in the works is going to be the joint employer test. For those of you who are in situations where you have a business relationship with another business, you share employees, you have common purposes, you're a franchisor, franchisee, please pay particular attention to the shifting sands of the joint employer test. The Trump administration and the Department of Labor rolled out a very employer-friendly interpretation that is currently tied up in appellate proceedings. And I don't think that I think those court cases are going to become moot, because I think the Biden administration, I don't just think this, I know from having listened to some of their guest speakers. Leonard Court and I are members of the U.S. Chamber of Commerce. Leonard is the subcommittee chairman for Wage and Hour Committee. I sometimes guest chair that as well in DC, and we have heard directly from the Biden administration that they plan to move to the economic realities test. What you need to know about the economic realities test is there's less focus on sort of the nuances of who's actually directing the day-to-day responsibilities of the employees, and really whether or not as an economic reality, the benefit gained by the employers is such that they should both be treated as employers. And I will tell you, that means franchisors and franchisees, get ready. You will almost always be found to be employers and not joint employers, excuse me, and not just sort of a bifurcated relationship between those parties. I can tell you exactly how this is working out. I'm in a case in the United States District Court for the Western District of Oklahoma, where the Department of Labor has been suing a client for about 4 years worth of litigation. That new DOL rule came out last year. The district court judge put a stay in place and said, I don't know, this entire case may change based on what that rule is, and also what the outcome of the election is going to be. And so we've all been waiting, and now the judge just last week issued an order and said, now game on. And also now the parties are going to have to brief to the court why we think the new rules will change things. I can tell you, we're on the losing end of the argument as opposed to the winning end of the argument, and nothing changed. The facts are exactly as they were. Even the Department of Labor had confusion. They couldn't decide what they wanted to argue in their own briefs because they couldn't decide which interpretation they were supposed to follow. So it is a chaotic time. If you're in litigation, my condolences. If you've stayed out of it and you've been on the sidelines, please pay attention to these changes because it could impact you moving forward. Speaking of which, independent contractor, huge battleground fight. I think it was the third day of the new Biden administration that they came out and said, hey, you remember that new independent contractor rule that got put in place by the Department of Labor after all that work and all the public comment and all the research that went into it. It's done. It's suspended, and I don't expect for its interpretation to see the light of day. Instead, we again have it on good authority from those who have spoken to the Chamber of Commerce that they are planning something that is probably one of the more controversial moves along labor and employment lines, and that is a move to, there's that state again, the California ABC test. So the ABC test essentially says, if you're going to be, if you're going to prove that somebody is an independent contractor and not an employee, then you have to make sure you meet all three of the following conditions. One, that person is free from the control and direction of the hiring entity in connection with the performance of the work, both under contract for the performance of work and in fact. So it's not enough how you label it in the contract. It makes a big difference. And let me tell you, if you've got independent contract agreements and they're coming up for renewal, you need to have them looked at by legal counsel that have an eye on some of these tests. But also in fact. So there's going to be hard to look at not just what you say the relationship is, but what's really happening. The person that is the independent contractor, this is factor number 2, has to perform work that is outside the usual course of the hiring entity's business. So, the quintessential idea, of an independent contractor is usually like a roofer, all right? My roof gets hailed on, I get a roofer, it's a one-off, they're doing other roofs in the neighborhood, I'm not really controlling what they're doing, they're bringing all their own equipment other than insisting that they're bonded and that they don't do it on Saturday morning when I want to get just a little extra sleep. I don't have much control over how that's going to be done. Well, this kind of shifts it the other direction, which is if they're not doing any work outside of what you entered into that business relationship with them for, the litmus test is going to be that, well, you've now failed the second factor. So imagine some of these independent contractor relationships out there where over time, they last a long time. It's primarily what that person does and maybe exclusively what they do. You're going to have a hard time under the ABC test getting there. And then finally, C, that person must be customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So in other words, a roofer would be fine. They've got an independent trade, occupation, or business. However, if you're just hiring somebody to do, I say hiring them, you're entering into an independent contractor relationship with someone who's essentially just supplementing your workforce with something that you could have someone else do or even have someone else do, you might fail the ABC test if that is what the DOL angles towards. Now, this is where it gets tricky. The Department of Labor, when looking at the interpretation that they put into place last year, already said the ABC test doesn't work and that it is at odds with congressional intent in existing law, which means not for the first or the last time, more like about the zillionth time, DC is going to talk out of both sides of his mouth and going to tell us last year that it was illegal to do this, and this year tell us that no, it's perfectly permissible. How will they do that? I think they could use the Congressional Review Act to both overturn the rule and put into place new language, as the Trump administration did previously in 2016. Or don't forget that there is the PRO Act, which is an act that is meant to help stabilize and facilitate unionization efforts, as well as the workplace or the Worker Flexibility and Protecting Small Business Act. Both of those already have ABC language that was snuck in through the legislative process, and it could be relied on to say, well, if it's legal there, maybe it's legal without having to amend the Fair Labor Standards Act, or maybe we'll just see Congress use its supermajority to make changes to the oldest employment law on the book. It started as the Portal to Portal Act. The 1938 Fair Labor Standards Act is due by anybody's standards for some updating in terms of its salary test, its duties test, and other areas. But maybe what we'll see is even a change to language that will better precipitate changes that allow for the ABC test. I try not to be political at all in giving these discussions. I mean, generally speaking, I'm apolitical on these issues. I know what's better for my clients and employers. I know what's more burdensome. I don't make any policy judgments one way or the other on that. But I probably am showing just a teensy bit of my frustration with the independent contractor situation, because this is just such a colossal flip-flop, and it whipsaws employers over the course of just 2 or 3 years between extreme business relationships that frankly impact not only the Ubers and Lyfts of the world, which will be greatly impacted by all this, but also just those of you who are using independent contractors as a great way to help get some work done, but avoid taxes, avoid business relationships that create liability under certain federal statutes, and frankly give flexibility to both the employer and the independent contractor that I think frankly we could see go by the wayside in the very near future. And that's less to do about politics and more to do about just how chaotic employment law has become, along with just about everything else in our average daily lives in the last couple of years. Okay, what about OSHA? What will we see in terms of big changes there? Well, here's what you need to know when it comes to OSHA. They have already received specific guidance and a new rule, even now within the first 30 days of the administration, on how employers must protect workers. All that's happened is that they are putting an increased focus on what's known as the general duty clause. OSHA has a lot of specific rules for what you have to do to track injuries and occupational illnesses, but the underpinning to all of OSHA is the general duty clause, which essentially says you're accountable for protecting your employees. And using the general duty clause, the Biden administration, and through OSHA and its implementation of rules, regulations, and guidance, would essentially convert our current Centers for Disease Control and OSHA guidance to make it mandatory, meaning that it's not just enough to protect your employees, but you will become more responsible for how you protect your employees, meaning that a lot of those issues that I talked about earlier are going to be under the microscope. What are your policies? What is your training? What level of inspection of PPE have you done? What level of provision of PPE have you done? How stringent are your masking protocols, your social distancing protocols, your hand sanitization protocols, travel restrictions? What is your pandemic plan? Do you have one? And how vigorously is it enforced? I have talked with employers who have wonderful plans in place, policies and procedures that, if followed, absolutely could be the tonic that is needed during a pandemic in terms of liability exposure. However, during the course of investigation or even a simple review of social media posts, you find people talking about employer workplaces where people are not covering themselves with masks completely. They're not following the restrictions. I have seen many businesses that have almost prided themselves on the fact that they're not going to follow some of those rules. OSHA is going to be a major tripping point for that mindset, but more importantly, because I know most on this Zoom call, if not all, are at a workplace where you've been very diligent about making sure to follow all of the applicable rules, but merely having the policies will not be enough. It is time to conduct an OSHA audit if you haven't already done so. My good friend and law partner, Alan Hudson, has been doing them left and right for employers. Whoever your employment counsel of choice is, you should be having that discussion sooner in 2021 rather than later. Okay, as we round the turn and head towards the end of our time together here, I do want to also talk about what new legislation we may see. You've noticed, no doubt, that throughout this time together, I've talked to you a lot about regulations, interpretation, enforcement mechanisms, but there's got to be something that Congress can do, right? Particularly the supermajority. You know, could we have actual new laws on the book? And I think that we will. One of those, I think, will be the reintroduction of the Paycheck Fairness Act. You may remember this. It's been shot down in the past. It is a favorite of politicians on the left. It is not a favorite of the business community. The Paycheck Fairness Act would essentially eliminate almost any factor that employers can use in order to pay employees differently. And that's going to be things like education, experience, the geography. Some areas, Oklahoma doesn't pay as much as should I say the name again, California. But there is, within the Paycheck Fairness Act, if reintroduced in its original form, that unless you can tie that to a business necessity, which is broadly defined as your business is going to shut down if you don't get to take this into account when paying your employees, then you don't get to use it as a differentiating factor, which is going to be a major boost for plaintiffs' attorneys who are looking to bring non-equitable pay issues in a class action setting or even on an individualized setting. A good one, again, to track, be aware of, and it's not a bad idea now to do an audit of your payroll practices and remind yourself what factors you use, what business models are out there, what data you rely upon, because even if the Paycheck Fairness Act doesn't make its way through, there will be attempts by the DOL to try to engraft as many of these considerations into enforcement as possible. I do think that we're going to see legislation, I mentioned it before, as it relates to paid leave. The FFCRA has created that precedent. It was done in a short amount of time. Even the Trump administration created already a paid family leave benefit for federal employees. So the predicate is there. The framework is there. The thing that is worrisome for me, and particularly for any of you who have multi-jurisdictional operations, most of the current bills that I have read lack state law preemption, meaning that that doesn't necessarily preempt what certain states already have in the books for paid leave. One of the tools of the right has been, look, let's go ahead and have paid leave, but let's include a preemption within it so that it preempts those state laws that go beyond what the federal law does. But if that preemption is not in there, and so far I haven't seen it, then for those of you with multi-jurisdictional operations, you're going to still have to pay attention not only to what the feds are doing, but what the state is doing as well. Finally, I alluded to this earlier. Are we going to see a federal minimum wage hike? $15, I think, is pie in the sky, but we are going to see a raise. I feel quite certain of it. Even President Biden has cast some doubt on it, as I mentioned earlier, but the fact that it's in the COVID-19 relief bill means it's already front and center. If it gets chopped out or just reduced altogether during negotiations, that won't be the last you hear of it. And it's happening. It started on the coast. It's leaking in towards the rest of the United States in municipal and state law changes. And we will see it at a federal level. It's just a matter of when and how. And so that's a whole lot of stuff that is coming down the pike. And I would imagine probably creates just a little bit of heartburn for those of you who are doing your level best just to make sure that you still remember all the changes that have happened in the last 4 years. But as a shameless plug and as a show of dedication and love for the group that I help lead as part of the firm that I've spent the last 21 years at, I wanted to remind all of you that those shiny faces, shiny happy faces up there on your screen are those lawyers within the group, within the firm, who are our principal labor and employment group attorneys. We have grown in our numbers, and that's because the needs of our client base have as well, and we couldn't be happier to serve those of you who need the help and assistance and legal counsel and advice that we provide. So you'll see there in that final slide, contact information for each of our 3 offices. For me personally, I always enjoy hearing from people who have seen my presentations, particularly when you lead with something like, gosh, that was the best, or how do you do it? You're amazing. I will read the rest of the email, guaranteed. But even if you omit those parts, I'm sure to want to help any way I can with any follow-up questions that you have. If your questions involve very specific circumstances where legal advice is required that goes beyond kind of what I do in these seminars, we may have to discuss how best to handle that. But I promise I do my best to answer questions and help out wherever I can. So I think I'm going to back out of my document now. And if there's any time left, Heather, I'll be happy to answer any questions that have been submitted or that people want to jump on and ask of me.
Okay, excellent. We did have one question sent in. They are wondering if there is anything addressing bereavement leave, especially due to the pandemic.
Yeah, nothing specific as it relates to bereavement leave, except to the extent that it could be folded into some of these paid leave requirements, but nothing in the extension of the FFCRA and nothing in the COVID stimulus bill that I have seen specifically addresses that. But remember, that's subject to change. And I would be surprised if you don't see some attempt to address not only the need for leave to caretake, but also to grieve those who are gone. But at this point, not at the federal or the state level have I seen that specifically addressed. And I should mention, I'm really glad that the viewer mentioned that question. There is a state law that was passed in Oklahoma in May of last year, Senate Bill 1946, that allows for immunity to certain kinds of liability for employers, provided that they adhere to at least 2 of several enumerated sources for adherence to certain standards. CDC and State Department of Health rules are part of those. So remember, I've really focused on federal change today, but that law is still kind of circulating its way through the court system. Excuse me. But keep an eye on state changes as well.
Great. Thank you very much for that. So let's see. It doesn't look like any other questions have been submitted. So if there are any, we just have, looks like 1 minute before 1 o'clock. So speak now or forever hold your peace, I guess, kind of. So let's see.